Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Appreciate you being here today, and I hope you enjoyed the drive up here. I want to take just a few moments before we get started and let's talk about our procedure. Obviously, we've got experienced practitioners all throughout the courtroom, and this is not your first rodeo, so I always feel better, though, knowing that we've gone over it. At oral argument, each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may do so. You may reserve up to 5 minutes of rebuttal time, and the proper procedure for doing that is after you've come to the podium and introduced yourself, but before you begin your argument, to request that from the court. Obviously, appellees get no oral you get oral argument, you don't get any rebuttal time. We have a timing mechanism on the podium. We believe it's very straightforward because we've seen it hundreds of times. It still confuses some people. When you begin your argument, the light will turn green. So long as the lights are green, you got plenty of time. Once the light turns yellow, it means you're running out of time, and we ask you to think about that. And once the light turns red, you're out of time, and we ask that you please respect those time constraints. Probably one of the most important things that counsel needs to understand is this. All these arguments are being live streamed. So whatever you say, you can't reach out there and pull it back. It's gone. So think about what you're saying before you say it. We've had instances where people have not thought that through, and there have been some embarrassing situations in the past, and we just want to make you aware of that. Your panel this morning consists of Judge Karma McGee from Savannah, Judge Valerie Smith from Memphis, and I'm Steve Stafford from Dyersburg. This is Judge Smith's maiden voyage. She has served as a circuit judge, many of you are aware of, in Shelby County for several years. She was confirmed by the legislature last month, and so this is her first time sitting at oral arguments, and we wish her a long and prosperous career. And welcome to the Court of Appeals. Miss Angie, anything we need to take up before we call the first case?
No, Your Honor.
All right, you may call the first case, please.
Walker and Associates, Inc. versus Cecilia, Walker, Norris, Heffington, et al.
All right.
Good morning, may it please the court.
Good morning,
I'm Lewis
Mr.
Jenkins, and I'm here on behalf of Walker and Associates and Seal Walker. I would like to reserve 4 minutes for rebuttal, please.
4 minutes, Mr. Jenkins.
Yes, sir.
You may proceed. You may proceed, I'm sorry.
The facts and the issues in this case are fairly straightforward. The real question is whether or not an email exchange that occurred that's not disputed and that is set forth in the record several times by both parties constitutes a complete and binding settlement of the underlying litigation. For the reasons that we've given in our brief, it does not. That email message, which we've copied as an image on page 21 of our brief, indicated that it had basically 3 things that were included in the message. Defendants to pay Walker the lump sum of the, it's been redacted in the record, it's since been put in the public record, it was $75,000 within 14 days of execution of a separate confidential settlement agreement to be prepared by counsel for the parties, mutual release by all parties to dismiss their claims with prejudice within 3 business days following payment. The parties then attempted to between their counsel, negotiate that confidential settlement agreement. And despite the exchange of what at the evidentiary hearing, I don't think it was disputed that they exchanged 7 versions of that agreement, and they were unable to reach something that everyone could agree to. And so the defendants proceeded with a motion to enforce the settlement, and the trial court said it was going to enforce the settlement, but importantly, it determined at the hearing in August of 2023 to enforce the settlement that it could not determine what would have been in the confidential settlement agreement, and so it reserved that for an evidentiary hearing. It gave the parties an opportunity to negotiate what was going to be in that agreement, and then it later set on July 17, 2024, an evidentiary hearing to determine what the terms of that confidential settlement agreement were. And at the end of that hearing in July of 2024, the trial court said, what I found, or what I held on August the 10th of 2023, was that the parties had come up with an agreement, the specific terms of which today, after having an evidentiary hearing, I realized were not necessarily hashed out. That is on page 102 from line 21 to page 103, line 1 of the transcript from 17 July of 2024. This appeal, despite that express statement on record by the trial court that it could not determine what the terms of the confidential settlement agreement were, the trial court just said, I'm going to enforce this settlement without the confidential settlement agreement. But in effect, that is making a new agreement for the parties. This email exchange said specifically that the defendants were to pay Walker, that was both of my clients, Seal Walker and Walker and Associates, the sum of money within 14 days of execution of a separate confidential settlement agreement to be prepared by counsel for the parties. The email did not say what the terms of that confidential settlement agreement were to be. It did not say that, as we sometimes probably inadvisedly put in mediation agreements, that it was to be a settlement agreement with standard terms. It didn't say anything about that, what that was. And then it turned out that the parties did not actually have an agreement because they could not determine what was going to be in the confidential settlement agreement.
Mr. Jenkins, did your client testify at the hearing as to what topics or issues were supposed to have been included in that confidential settlement agreement?
She did, yes, ma'am. She gave, I think, what would be fair to say, a summary of 4 broad areas that were going to be included in that agreement. And those had to do with the operation of the business, the repair of the breach that had happened in the family, the cessation of competition by the other side, and the coming back to work of the daughter who had been one of the defendants in this case. And it turned out, I think, that it was pretty clear after she gave that testimony, and Mr. Heffington, the only 2 people who testified at the evidentiary hearing on July 17, 2024 were Ms. Walker and Mr. Matthew Heffington, I believe. And so it turned out that it was clear that they had not been able to reach agreement on those items that were included in the discussion, and that they were expecting to be able to hash that out in the confidential settlement agreement, which did not happen. And, you know, does that answer your question, Your Honor?
Well, yes, but let me ask you a follow-up question to that. So Mr. Heffington testified as well at the evidentiary hearing, and I've read the briefs, but I haven't been through the transcript and looked at but what was his position as to additional topics or issues that were to be covered? Was his testimony the same as hers on that?
So I would say that his testimony was the same as hers to the extent that that he agreed that all those topics had actually been discussed. I mean, there was I don't think there was much of an issue. There was a written agenda all 3 times that they met, and those written agendas about what was to be discussed were included in the record. So I don't think there was any dispute that those things were actually discussed. And I don't think, after my client's testimony in the trial court, that there was a dispute that they did not get to a final agreement about those things. The difference in their testimony was Mr. Heffington basically said those things were going to be taken care of after the lawsuit was dismissed, and my client's testimony was that they expected those things to be covered in the confidential settlement agreement. So they agreed, yes ma'am, up to a point, but past that point they didn't agree with each other. I think it's fair to say Mr. Heffington said those things are going to get taken care of after the lawsuit was dismissed. And my client said, no, those were the things that our lawyers were supposed to put in the confidential settlement agreement. And so, you know, I think these cases about this, and there are lots of them, as the court is aware, they fall into 2 broad categories. And when you put them in those 2 broad categories, you understand why there was no settlement agreement in this particular case. Number one, they fall into this category of like the PNC case, the PNC versus multifamily capital case, in which there, for example, there's a judicial settlement conference, and a former member of this court who was, when he was on the trial bench, Chancellor Armstrong, later Judge Armstrong in this court, had conducted a judicial settlement conference, and there was a memorandum prepared at the end of that judicial settlement conference that set forth all of the terms of what was going to be done after the, and it did say they were going to execute a more formal document. But in that case, there was no question that the formal document was going to contain the terms that were in the memorandum that had been prepared at the end of the judicial settlement conference. And so all that happened there is that once the formal documentation embodying the terms in the memo from the judicial settlement conference was presented to the one party, he just wouldn't sign it. So that's the first category. They're just refusing to sign a document that transfers from a less formal document to a more formal document, all of the same terms. And then sometimes, that I think in that same category, sometimes people feel that they even after their lawyers have reached an agreement and they've sent that agreement back and forth by a writing, by lots of times by electronic mail, as happened in the Waddle versus Elrod case. One party just said, and that's also happened in the Hayes versus Extreme Excavating case, one party just says, I'm revoking my agreement because we haven't yet signed the formal agreement. I'm revoking my agreement. And then there are the second category of cases, the case like the Hardy versus Turner case, which is a case that the appellees relied on heavily in their brief, and that I've explained in our reply brief actually supports our position. That is, they had negotiated a detailed agreement. The lawyers came to court, announced the detailed agreement, even made the statement that all the essential terms of the agreement were being announced to the court. And then after they translated that transcript into a settlement agreement, one of the parties said, oh, there's something else that should have been involved. That was the placement of this sewer line. And he wouldn't sign the agreement because there was another agreement that hadn't been included. And the trial court in that case, and this court in the appellate decision rightly said, you can't add something after you've announced that you've got all the essential terms. There was no document that said what all the essential terms was. There was no representation that the email of November 2nd, 2022 contained all the essential terms. There was simply a statement that they were going to make another agreement based on that agreement. And for this reason, there is no enforceable settlement in this case. And my time is up, and I'll sit down and take my 4 minutes.
Good morning.
Morning.
Jonathan Hancock from Baker Donaldson. I'm here today with my co-counsel Preston Battle, and we are here on behalf of our clients, the Appellees, Cecilia Walker Norris Heffington, her husband Matthew Heffington, and her business, which is Cecilia Lona LLC. I do want to start out thanking the court today. I agree, though, with counsel. This is a pretty simple case. And I also agree with counsel, there is one issue in this case, and that issue is whether the emails exchanged constituted a binding settlement agreement. We disagree about whether that in fact happened, but the law in Tennessee is pretty straightforward. And in fact, there are a number of cases where emails served as the basis for the settlement agreement that was under review by the court. And in all of those cases, the emails look just like ours. In each of those cases, the emails contain the same elements. They contain an agreement to transfer property and in exchange an agreement to dismiss a lawsuit. They also say things like we're going to prepare a settlement agreement. And counsel mentioned the extreme excavator case. In that one, the court correctly pointed out that that's normal. We do prepare settlement agreements after the fact, but those agreements only memorialize the terms of like we do, like a term sheet at mediation. And in fact, they're only there to become the more formal expression of what we've already agreed to. And here, what the parties already agreed to, we can tell because it's in the email. But there are a few things. Our clients not only contend that they had an enforceable settlement agreement, they also contend that the email that memorializes that agreement was almost identical to the one in Waddell versus Elrod. And in that case, in 2012, the Tennessee Supreme Court gave us some pretty good milestones for a review of these cases. First, the Tennessee Supreme Court was very clear that a settlement agreement made during the course of litigation is a contract between the parties. And as such, contract law governs disputes concerning the formation, construction, and enforceability of that settlement agreement. It's important because we're not talking about a summary judgment that got to the underlying merits of this case. We're not talking about that because they settled it in a way that allows this court to avoid that discussion. All we're talking about is whether or not the agreement to settle this case created an enforceable contract. And there's no question here it did. You had offer, you had an acceptance, and you had a written expression of that. The court in Waddell, though, did a few other things, and among them, the court looked at the context in which that case came before it. What happened in that case was there was a group that was about to go to trial, and on the eve of trial, one of the lawyers sent the other one an email indicating that his client would agree to a resolution if they could avoid trial. That's not all that different than what we have, because with that intent in mind, the Supreme Court looked at that email. And what it found was that the email had an agreement for one party to transfer property, just like what we have, and an agreement that the lawsuit would be dismissed with a full release. That's exactly what we have. But I want to touch a little bit more on what the context the Waddell court looked at and what Justice Clark wrote about it, because counsel correctly summarized the underlying dispute. But he didn't really point out the fact that this is between a mother and her daughter. And what Chancellor Taylor Jefferson did know is that unlike a standard employment case where you've got an employer, this one had parties that were related. And I highlight that because it's the context in which this case was settled. As our record clearly demonstrates, Ms. Walker, and she's who owns Walker and Associates, it's the employer in this case, invited the parties over to discuss this settlement. Ms. Walker is Ms. Heffington's mother. During the pendency of this case, Ms. Heffington had given birth to she and her husband's only child, which was Ms. Walker's first and only grandchild. That's the context and the backdrop in which these meetings were held. Ms. Walker asked them to come to her house. They met for 3 days, and they met for more than 7.5 hours. And at the end of that meeting, there was a very pivotal act, and that's the sending of this email. Those are the facts that we think are very important to highlight the most, and it's why I disagree with counsel.
Let me pose a question for you. Do you agree that the execution of a separate settlement, confidential settlement agreement is a necessity?
No. We
Does
did
the-
not have
does
to
the-
have a settlement agreement here.
Does the agreement itself not contemplate that?
The court, it does, but that doesn't, I don't believe that the offer and acceptance are not destroyed by the failure to create a settlement agreement. And the
But
reason
isn't it a requirement of what you agreed to?
No, and the reason is because Ms. Walker refused to sign the settlement agreement.
Well,
And one party,
no, I'm talking about just the agreement itself.
well, it would
The
be,
agreement between the two parties. Does that agreement require a separate confidential settlement agreement?
it doesn't require it. No, and the reason that I say it that way, Judge Stafford, is because in the context like what we have, where a party refuses to sign it, that underlying agreement isn't rendered unenforceable because someone refuses to sign a settlement agreement. And that's what we have here.
Well, isn't there a difference between it being unenforceable and the parties being unable to agree to the terms?
Yes. And here, if that's what we have, the parties were unable to agree to the terms. And
So, if the parties are unable, where are, I think Judge McGee asked Mr. Jenkins this question. Where are the parties different on the terms, or where do they differ on the terms?
We tried to get into that in the trial court's evidentiary hearing as well. And when I asked Ms. Walker under oath if she could identify any additional terms they agreed to in that meeting, the answer was no. She could not articulate a single term. In
Then
fact-
where's the hangup then?
I'm sorry?
Where's the hangup in the execution? Is it, as Mr. Jenkins posited to the court, that the terms that must be performed before or after, or what's the problem here?
The problem was, after the agreement, what Ms. Walker testified to was that she wanted, among other things, for Ms. Heffington to return to Walker & Associates as an employee. That wasn't agreed to at the meeting, and in her testimony at the evidentiary hearing, she said she wanted that included in the settlement agreement, and she wasn't going to sign it because that wasn't in there. And what she essentially admitted during that hearing was that she wouldn't sign the settlement agreement that was proposed, multiple versions of which were proposed, because she wanted to add additional terms. And that's where the settlement discussions broke down. That's what the posture in which we brought this matter to the Chancery Court, that we have reached an agreement. We've even proposed a written settlement agreement that only includes the terms from the email, and she still won't sign that. And that's why we asked the court not only to enforce the settlement agreement, but to require her to sign one. And if she would not sign one, we asked the court to enter an order memorializing the terms of the settlement. And that is what the court did. It's important to talk about, though, the end of that third meeting. At the end of the third meeting, when Mr. Heffington sent the email, he was very clear about the terms, but he didn't send that in a vacuum. They were sitting in Ms. Walker's house. She had an opportunity to read the email, to talk about the email. She accepted it there before the email was typed, but she further reinforced her acceptance when he sent the email and she replied, "I agree. I'm happy to have my family back together." And that's why that context is so important, because this didn't just settle a case, it put a family back together. And she admitted that when she agreed it. After the case was settled and the email confirmed it, Ms. Walker just changed her mind. And we did get into some of the terms she wanted to impose under this agreement. All of them were specious. None of them were things that the parties were able to agree to. And what really happened, they discussed a number of things during this 3-day, 7.5-hour negotiation, but not many of those were agreed to. The only ones that were agreed to were the transfer of $75,000 in exchange for the dismissal of the case.
Mr. Jenkins suggested that there was an agenda for this discussion.
There was an agenda. That agenda was prepared by Ms. Walker, and I believe it was her effort to identify what she wanted to talk about during these meetings. Mr. Heffington testified at the hearing that he was never even in possession of that agenda. He saw it in her hands, and he knew she had it, but that he didn't even have a copy of it. I think the agenda could also be called talking points. It was things that Ms. Walker correctly wanted to talk about during these negotiations. Most of those things, though, did not reach an agreement. And that's why when we get to the point where there's an email, it's not a long email. There are not 5 or 6 terms in here. There really are just 2. An exchange of the dismissal for a payment of $75,000. Those emails, though, are important. They're the same as all the emails in every appellate case in Tennessee, where the court is reviewing the email to determine whether or not there's been a valid and enforceable settlement. And in Hayes versus Extreme Excavation, Waddell versus Elrod, in all of these cases, you have the same thing. You have somebody who reached an underlying agreement to settle a case if you paid me an amount of money. That, in each of those cases, was sufficient for the court to find a binding contract, because there's offer, there's acceptance, and it's in writing. That's what we suggest this court should do, because the Court of Appeals in Harvey spoke exactly to those issues that we say Ms. Walker identifies, and those issues weren't germane to the settlement of this case. In fact, go back to the issue about Ms. Heffington returning to Walker & Associates as employee. Speaking to that, the court in Harvey said, these matters cannot, however, be considered essential to the settlement of the lawsuit if they're not raised as issues in the lawsuit. She never asked for Ms. Heffington to be forced to return to Waddell & Associates in the lawsuit, because you can't. There is no Tennessee law where an employee can be required to return to work for an employer. That wasn't part of the lawsuit, because it couldn't be. And so the issue that hung up the settlement isn't even required for a complete settlement. And that's what the Court of Appeals was struggling with in Harvey, when it found those terms weren't part of the lawsuit, so they weren't necessary to reach a full settlement. At the end of the day, the parties here did exactly what this court and public policy in Tennessee wants them to do. We went to mediation, the case did not settle. Months later, the parties met independently without their lawyers. That's interesting. The lawyers were involved. We knew about it. Had the parties needed support during these meetings, they could have called us. During the periods between the meetings, we spoke with our clients. They were supported, but they made the decision to settle the case. And then they did the smart thing and memorialized it in an email. And that's why Tennessee law and Tennessee public policy favor enforcing this settlement. And that's what we ask this court to do. Thank you.
Thank you.
Well, the first thing is, I don't think I can detail in 4 minutes why this statement, which Mr. Hancock made about 4 times, that the emails in these other cases are just like the emails in our case, is wrong. But in fact, it is just plain wrong. And I'm going to share one of those with you, the Elrod case. And I've given the details of every one of these in our brief and our reply brief. In the Elrod case, the email said this: the day before trial, Ms. Elrod's attorney, Mr. Gregory Reed, advised Ms. Hagan, counsel for Ms. Waddell, that Ms. Elrod was willing to return her own 1/2 interest in the Prim Lane property to avoid going to trial if Ms. Waddell would settle the case and release all other claims against her. Through her attorney, Ms. Waddell agreed to settle the case on the conditions that she would not be responsible for any of the court costs. Around 4 p.m., Mr. Reed advised Ms. Hagan that Ms. Elrod had agreed to settle the case with Ms. Waddell's condition. At 4:34 p.m., Ms. Hagan sent the following email to Mr. Reed: Greg, this confirms that we have settled the case on the following terms: Elrod deeds property interest back to Waddell. Both parties signed full release. Waddell bears no court costs. Let me know if I've correctly stated our agreement. Thanks, Mary Beth. At 5:02, Mr. Reed responded, that is the agreement. I understand that you will draft the deed and take a shot at the court's order. No admission of guilt is to be included. There's nothing in there about a separate agreement. It was a deed to a piece of property, the Prim Lane property, that had been identified in the email.
Did that email not refer to a full release that the parties would sign?
Yes, it did to a full release of claims, which had been further explained by the fact that release all other claims against her. So there was no question about what the content of that was. It didn't say a settlement agreement. It just said release those claims, which actually was going to be done by the court order by dismissal with prejudice in that case. So that because what then happened is that they drafted the deed, and then the lady wouldn't sign the deed, turning back over her half interest. She just refused to sign it. She didn't say there's a separate agreement that's got to be signed. She just wouldn't sign it. And the specific legal issue in that case is whether or not that email complied with was sufficiently definite to meet the definition, the requirement of the statute of frauds that agreement to transfer land be in writing. And that was the issue that was decided. If you look at Harvey, or you look at PNC, or you look at any of these other cases, especially the extreme excavating case, they actually had reached an agreement with all the terms. And the only thing left to be done was to sign a release saying that we're releasing all these claims. There were no other terms that were included. And in fact, I want to say one other thing. Mr. Hancock said that the child was born during the pendency of these negotiations. That's wrong. The child, that's not in the record either. He just sort of added that. But the fact is the child was born while these hearings were going on, not while these negotiations were going on. In fact, in November of 2022, the child hadn't even been conceived yet. So the child, I think, was born in January of 23, January of 24, after all these things had already occurred. If you just took the trial court statements, if you just took the trial court's findings, both times in August of 23 and in July of 24, where the trial court said, I can't figure out what the terms of this agreement were supposed to be. And you combine that. Can I finish this sentence?
Sure can.
And you combine that.
I've never seen you do that before, Mr. Jenkins.
Well, I'm live, Your Honor, so I wanted to respect the rules. And you combine that with the statement by Mr. Heffington that we've quoted on page 10 and 11 of our brief, which came from the statement in 121 of the record about this email, where he said, after additional thought and consideration on our conversations last Wednesday and your emails today, we've had our lawyers add some additional language to the settlement agreement that memorializes our discussion on this issue and recognizes our joint intention that we work together. I mean, all these things were discussed, and even Mr. Heffington agreed that these things were to be included, and he went back and included some of them, but not all of them, because they couldn't reach the final agreement on all of them. And this case needs to go back for a full disposition after motions and trials, and that's the request we ask for.
Thank you.
Thank you. Have a good morning.
You too. Thank you, gentlemen. We appreciate your argument. We will take this matter under advisement, review the record, and attempt to get you an opinion at the earliest time. Thank you. You may be excused. Ms. Angie, you may call the next case, please.